Hello, I'm Joshua Rosenberg, and this is the very first in a new series of podcasts which I'm calling A Lawyer Talks. You may know that I used to do a programme for BBC Radio 4 called Law in Action. I launched the show in 1984 and I presented the last programme almost 40 years later at the end of March this year. Like Law in Action, and like my Substack blog, A Lawyer Writes, the aim of this podcast is to demystify the law. You don't have to be a lawyer to enjoy A Lawyer Talks. You probably do have to be a lawyer to answer a question like this.
To your knowledge, did Mr. Green know, or his team know, that there had been concerns expressed by criminal lawyers that Mr. Jenkins had actively misled courts?
I've already answered that question.
No, you haven't. You've diverted yourself from the answer.
If I may say so, that is not a proper point to put to me.
Stop before you start, Mr. Grau-Robertson? I don't want a situation developing where you and Mr. Steen have an argument.
More of that and expert advice on how to ask and answer questions in court later. But first, listen to this.
Betty goes to the front door because when the doorbell rings, what else can you do? Her fingers fumble on the latch. She opens it. She did not know how frightened she had been until she sees Susan standing there. The child is alone. A plastic carrier bag hangs from her hand, heavy with fish and chips. Susan. Relief brings irritation. Did you forget your key? And then, where's Uncle Jason? And finally, because Betty can no longer ignore the fact that tears are pouring down her daughter's face, what's wrong?
Thank you, Wendy. The first lawyer I'm talking to on A Lawyer Talks is Her Honour Wendy Joseph KC. Her latest book is described as a compelling read by the former Supreme Court President Lady Hale and as a beautifully written, immensely engaging, powerful and disturbing insight into a judge's work by the best-selling crime writer Peter James. After a career at the criminal bar, Wendy Joseph was appointed as a circuit judge in 2007. When she moved to the Old Bailey in 2012, she was the only woman amongst 16 judges and only the third woman ever to hold a permanent position at the Central Criminal Court. On her retirement, just over 2 years ago, she published an extremely well-received book called Unlawful Killings, and her new book, Rough Justice, will be released by Penguin Random House on the 18th of July. Wendy, we're meeting today at one of the ancient livery companies in the city of London, the Pewterers. I'm not sure I even know what pewter is these days, and I certainly don't know how you came to be crowned as master of the Pewterers last September. So before we talk law, maybe we should talk a little bit about livery?
When I went to the Old Bailey in 2012, I had only the vaguest idea of what a livery company was, but I was told that all judges there are expected, because the Old Bailey is the city court, to join a livery company. So I went home and I said to my husband, I have to join a livery company, and he said, oh good, what's that? And I said, I don't know. So we looked it all up on the internet and I made a choice, but I chose a very modern company. Now, the Pewterers is in fact a very ancient company. We are celebrating our 550th anniversary this year, but I chose one much higher up the list. I was then told by someone else whom I met at one of the dinners that judges have to go to, that it was entirely wrong I should be joining a new company when I wanted to join such an ancient thing as the livery, and I should think about joining his company, which was number 16, the Pewterers. I compromised. I joined both.
And what does a livery company do? What does this company do?
Well, essentially, they were originally guilds and linked to a particular trade or profession. And the name speaks for itself. It does what it says on the tin. But these days, they are essentially philanthropic organisations within a fellowship. So what you do is a lot of charitable work and supporting other institutions which we think are important to the country, but that we do it within the context of fellowship.
And pewter itself has changed over the years.
Pewter used to have a lead content. It is essentially tin. It's very soft. It's so soft that if you didn't add something else, you'd be in a bit of trouble with it. When the Great Fire of London happened, there were rivers of pewter running down the streets. But the addition of lead in particular became very problematic some time ago. There hasn't been lead in pewter for a long time, but there are other additional things now. So it's really tin with added extras.
Now, quite a few lawyers and even some judges have written about the cases that they were involved in. But your books are about the cases that you didn't do.
That's true, Joshua. I wanted to write about the system. The criminal justice system is really there for people, ordinary people. The cases are brought in the name of the people, that is to say, in the name of the Crown. The cases are tried, the big decision is made by ordinary people, the jury, and the laws are there to protect ordinary people. And yet, an awful lot of people were very confused about how the courtroom worked. So the aim was to explain what could happen in a courtroom and how it feels. It was sort of like saying, come and sit beside me on the bench and look across the courtroom into the eyes of a 16-year-old you're about to send to prison for life, or to let your gaze slip to the side and look into the eyes of the bereaved parents whose child the one in the dock has killed. However, I'm not the sort of judge who thought that my memoirs would be of much interest to anyone. I know they wouldn't be. And also I felt quite strongly it was just wrong to write about what people had already been through, whether they were the victims or the witnesses or the jurors or the defendants. They'd been through it, and I didn't want to resurrect all of that. So what I did was to choose discrete topics I thought were of interest, like gangs, knife crime, domestic violence, sexual abuse, and to go back through the cases I'd done and to pull out from them things I thought were of interest. And then I crafted stories around those things. So each story I've written is not real in the sense you couldn't go and look up that case with those defendants, with those names. But everything in them is true in the sense I have seen it happen in a courtroom.
And not just the defendants. What about the lawyers in your case studies? They're drawn from life too, aren't they?
If any lawyer thinks they can identify themselves in any of my stories, they should disabuse themselves of that thought. But I have drawn upon the odd characteristic, which I have seen in the courtroom, and applied it to the characters that I've invented.
Wendy, one of the things you do in your book is to give us the judge's view of the advocates who appear before you, the KCs and the junior barristers acting for the prosecution and the defence. Now, it's clearly not an easy job for any of those involved, and I thought we might ask you to give us a kind of masterclass in advocacy by asking you for your insights into some hearings that are attracting a great deal of interest here in London. I don't think we're ever going to see contested criminal trials on live television in England and Wales. But what we can watch in real time is witnesses being questioned at public inquiries. For example, the inquiry into the post office scandal, which is looking at how sub-postmasters were wrongly sacked, wrongly prosecuted, wrongly convicted on the strength of unreliable computer evidence. Last month, on the 22nd of May, the former chief executive of the post office Paula Venables gave evidence on the first of 3 days in the witness box. Let's hear Jason Beer, KC, who's counsel to the Post Office inquiry, and this was his first question. It's a classic, really.
Ms. Venables, in the light of the information that you tell us in your witness statement you weren't given, in the light of the documents that you tell us in your witness statement that you didn't see, and in the light of the assurances that you tell us about in your witness statement that you were given by Post Office staff, do you think you're the unluckiest CEO in the United Kingdom?
I was too trusting, Paula Venables said. Jason Beer then ran through more than a dozen things that she'd said she wasn't told or didn't see before asking her this.
If all of the facts and matters that I've just described are true, and if what you say is reliable, was there a conspiracy at the Post Office which lasted for nearly 12 years, involving a wide range of people, differing over time, to deny you information and to deny you documents and to falsely give you reassurance?
No, I don't believe that was the case.
Later, Jason Beer asked Paula Venables about Martin Griffiths, a sub-postmaster who took his own life after investigators had accused him of involvement in an armed raid on his own post office. Paula Venables told a senior colleague, "If it's an attempted suicide, as we sadly know, there are usually several contributory factors." So Jason Beer asked her this.
At this stage, why were you raising the fact that there were usually several contributory factors involved?
The first thing to say is, as I say in my statement, I am very sorry about this, and that just sounds too shallow.
She then said,
I would have to communicate something so serious as this to the board, and I think I was trying to find out whether there was anything else behind it. I had a personal experience of a previous post office colleague who had took their own lives, and I phoned.
At this point, Paula Venables paused for nearly 20 seconds. It felt like an eternity.
I phoned the family and I spoke to the father, who explained to me that there were other issues involved. And I imagined that, I imagined that I was probably...
Ms. Venables, just rather than trying to talk through your...
I beg your pardon.
Just pause.
Yes, okay.
Try and compose yourself if you can, and then continue your evidence, please.
Thank you. In this particular case, I had spoken to the sub-postmaster's father, who had said to me that there were other contributory factors in his son's death, and they were very grateful for the call that I had made. In Mr. Griffith's case, I also offered to do the same, and I was told by the General Manager of the Crown Offices that that wasn't needed and other people were in the loop.
That was Paula Venables answering questions on the 22nd of May. We've shortened some of the pauses. Wendy Joseph, you must have had to deal with emotional witnesses many, many times as a barrister and as an Old Bailey judge. Is it easier for a woman to question a female witness?
No, I don't think so. What is needed from an advocate is a degree of empathy, which is not the same thing as sympathy. Indeed, it could not be more different. But if you can empathize with what is going on, you can understand what is happening inside the witness's mind. And that allows you to formulate your questions properly. There's a great deal of judgment involved in being a good advocate. And the passages that you've just used are a very, very good example of that, because Jason was making some good headway, and then you will see the moment at which he had to retract, he had to stop, because he had reduced the witness to tears. I feel for Jason because he will not have wanted to do that. And what he did was to stop what was happening. Because the last thing you want to do when you're cross-examining someone is to create sympathy for them. And that is what was the risk of what was happening there. So you chose some very good extracts which demonstrate where it's going rather well and then where it's going not quite so well from the advocate's point of view. But to go back to your question, don't think it makes any difference whether you are a man or a woman. The one area I would say there may be a difference is where the nature of the questioning relates to the gender of whatever has been happening. So for a child to be cross-examined by a big-built, authoritative-sounding male figure when she is alleging rape by a big-built, authoritative-sounding figure may not be the best solution.
Now, in your book, Rough Justice, you deal with rape. You deal with areas where you say the courts have fallen short over the years: rape, domestic violence, child cruelty. And as you say, the victims are often women, the very young, mentally ill, physically frail. How effective are we at protecting these people?
Well, we try. It depends what you mean by protecting. We've done quite well at finding ways of protecting people within the courtroom. That is to say, we have provided quite a lot of features that make it easier for people to give evidence. So vulnerable witnesses can use a screen to shield them from the sight of the defendant and vice versa. They can give evidence from outside the courtroom. Their evidence can be pre-recorded. Their cross-examination can be pre-recorded. All those things can happen in certain circumstances. And there are other measures to protect them, special measures. But if by protecting them you mean something broader, you mean by giving them justice, you mean protecting them from being the victims of offending, well, that's a very different question. Because in the second book that I've written, I actually went back and found cases, historical cases, that matched up with those I was describing in the modern day. There is no doubt that we were able to offer the sort of protections that I've been describing to the modern day witnesses. But what was interesting was the results, the verdicts, were not noticeably different.
You're saying that even with all our protections, we get the same results. All the concessions to the sensitivities of witnesses, that they don't have to see the person they're accusing when they're giving evidence. You see the witness, counsel see the witness, but the person in the dock doesn't see the witness. And you're saying that despite all these changes, the result's the same. Is that a good thing or is that a bad thing?
Well, one might have hoped to have improved the situation with all the things that we've been putting into place. But the reality is that where there are two witnesses, and only two, to an allegation, the alleged perpetrator and the asserted victim, the same problems arise for modern juries as arose for jurors in the 18th century. The reality is that I was amazed to find when I had invented, described, drawn upon background to create a story about a child being raped and being cross-examined, and I put into the mouth of the barrister what I have heard come out of the mouths of barristers 1,000 times. if it's true, why didn't you tell your mother as soon as you got home? If it's true, why did you go back to his house again? To my astonishment, I found exactly those same questions being asked in a case I found in 1735. And I hadn't gone through 1,000 cases to find it. I simply typed something into the search engine and up it came. So the same questions are asked, the same problems for the jury have to be resolved. Who is telling the truth? Except, Joshua, the problem is, it isn't a question for the jury of who is telling the truth. It isn't a question of who we believe. It's a question of, can we be sure that the prosecution case is right? Can we be sure the prosecution witness is telling the truth? Because that is the burden of proof that we apply in our courts.
You're referring to a public website called Old Bailey Online, covers nearly 200,000 cases between 1674 and 1913. Now, you've told me that you put words into the mouths of the characters that you created, but I infer from what you're saying that you really did look up these real cases while you were researching the book, and you found real cases which you've described in what you've written.
Yes, what I did was to apply the same principle I had in the first book, in Unlawful Killings. So I was essentially drawing upon things I had seen happen in many cases and then crafting them into a series of short stories. But it occurred to me that it would be interesting, because I was dealing with all the things we've been talking about, like special measures. It would be interesting to see whether we really were giving better justice, better protection to those who claimed they were the victims of crime. And so I just began going back into the archives and putting into the search engine the sort of features that I'd put into each of the stories, and up came cases that really did have a significant resonance, or at least in some cases, I found cases that really had a significant resonance to that which I have seen happen day after day, year after year, decade after decade.
Aren't there restrictions on what an advocate can ask a witness these days in sexual offence cases which didn't exist centuries ago?
Yes. There's a very substantial list of subjects that you can't touch, and one of the most significant ones is previous sexual experience. That can only be cross-examined upon in certain limited circumstances with the judge's sanction. And so this is another one of those measures where really we have set out to make it easier for people to talk about, possible for people to talk about what might otherwise be impossible for them to talk about.
Let's stay with the subject of questioning witnesses and perhaps move back to our masterclass. I want to play you some more extracts from the Post Office inquiry and ask you in particular how a senior lawyer should handle the challenges of questioning other senior lawyers, or perhaps expert witnesses in the case of a criminal trial, people who know all the tricks of the trade. On the 11th of June, there were two witnesses at the Post Office inquiry, both of them senior barristers. The first one we'll hear from is Lord Grabbanner, KC. He was instructed by the Post Office in 2019. At that stage, the Post Office was being sued in the civil courts by postmasters who said they'd been wrongly sacked because of apparent shortfalls in their accounts. The claim had been divided into a number of separate trials, and Mr. Justice Fraser, as he then was, had ruled in favour of the postmasters in one of the trials, and he was about to start the next trial. But the Post Office came along and argued that he shouldn't hear the next part of the claim because it looked as if he'd already made up his mind, and that, of course, might have thrown the entire claim off course. We pick up the story when Lord Grabbanner, who's acting for the Post Office, sends an email to Lord Neuberger, who's a former president of the Supreme Court. He joined Lord Grabbanner's chambers when he retired. In this email, Lord Grabbanner tells Lord Neuberger that Mr. Justice Fraser's decision to hold a hearing on a date when Lord Grabbanner might not be available does rather confirm our suspicions about his Smith characteristics. As Jason Beer suspected, Lord Grabbanner was referring to a somewhat colourful judge who retired from the High Court after complaints about his conduct.
Is that a cross-reference to Mr. Justice Peter Smith?
Indeed.
Was this becoming personalised?
What do you mean by that?
No more and no less than the question.
Well, what do you mean by personalised as between whom and whom?
You and the judge.
Me and which judge?
The judge that had, you were applying to recuse himself.
Absolutely not. My view was that he had made a mess of that case. And that was my position. And that was David Neuberger's view as well.
Wendy, before I ask you what was going on there, I want to play you one more extract from earlier the same day. The witness was Anthony Degar Robinson KC, who represented the Post Office in the civil claims brought against it by postmasters. He was questioned by Sam Steen KC, representing the largest group of sub-postmasters, about a reference he'd made in court papers to a computer engineer, Gareth Jenkins. Sam Steen wanted to know whether Anthony Degar Robinson had explained to his opponent, the postmaster's KC, Patrick Green, that there were doubts about the computer engineer's reliability as an expert witness.
Did Mr. Green know that there had been concerns expressed by criminal lawyers that Mr. Jenkins had misled a court? Did he know that?
I have no idea. I would be very surprised if you please let me answer
that.
Please let me answer the question. However, I would say this: I have no doubt that Mr. Green knew that there were criticisms being made of Mr. Jenkins's performance as an expert witness in criminal cases. Of course, he knew that.
To your knowledge, did Mr. Green know, or his team know, that there had been concerns expressed by criminal lawyers that Mr. Jenkins had actively misled courts?
I've already answered that question.
No, you haven't. You diverted yourself from the answer.
If I may say so, that is not a proper point to put to me.
Stop before you start, Mr. Grau Robertson. I don't want a situation developing where you and Mr. Steen have an argument. So I'd be grateful if you both. First, Mr. Steen asks the question, then secondly, you give your answer without either of you trying to chop down the other. If
yes,
you see what I mean.
I do.
Very good, my lord.
Did Mr. Green know, as you did, that Mr. Jenkins had been viewed by criminal lawyers, instructed on behalf of the Post Office, that he had misled the court? Did he know?
I imagine not.
That was Sir Wen Williams, the retired judge who's chairing the Post Office inquiry, stepping in to keep the two cases apart. You have to be pretty hands-on as a judge, don't you, Wendy?
Yes, you do. That's exactly what you are there for. One hopes that counsel will get it right, but in the heat of the moment, they often don't. And I think, Joshua, it's just worth saying what we haven't said before, that the heat of the moment in an inquiry is very different from in a trial. I mean, there are really quite profound differences between what is happening in an inquiry and what is happening in a criminal courtroom. The most obvious one to look at is there is no jury. So you don't have a jury to play to. But the other one, which isn't so obvious, is it is inevitable that counsel will know that they are being, certainly in a high-profile inquiry, recorded, that they will be quoted, that they are being watched watched. And so you really are in a position where there is a risk that they may be playing to a bigger audience, even subconsciously. You may remember that at the beginning of this conversation, you said you thought it was unlikely we would ever have the broadcasting of live trials. And that is exactly why we won't do it in criminal trials, because it affects the way everyone in the courtroom behaves. Of course, in part because they are human, the advocates, but the jury, even the judge, certainly the witnesses can be affected by that. Those things don't go away just because it's an inquiry. So it isn't an exactly parallel position.
But on the other hand, you sit in public. There's a public gallery. Anybody can walk in. They can see you. But that's different from people watching on television?
I think it is. I think it is. I think there's a big difference between what happens inside a room, however big that room is. So when I sat on the bench at the Old Bailey, I would be facing everybody else in the chamber, because that is the way our courts are constructed. We did sometimes in the past have round courtrooms, but we really don't build them that way anymore. The judge is at one end of the courtroom. Everybody else is looking at the judge. That's not really of significance. What's of significance is the judge can see everybody else. And so the judge can control the courtroom. The judge can see what's happening and should be seeing what's happening in the public gallery, in the dock, in counsel's row, in the jury box. If a juror has closed their eyes, we want to make sure it isn't because they're falling asleep. Everything is subject to the judge keeping control of it. You think of judges as being lawyers. Well, they are, but in the Crown Court, they are very much man-managers. And it is very different from those who are, quotes, performing, unquote, from not knowing what is happening out there, how it's going to be used in the future. I just think it creates a very different atmosphere. And you could hear some of that. You could hear some of that going on in the clip that you played, which isn't to say these things don't happen in the courtroom, but just as Sir Win Williams did, you would expect the judge to step in, and in a Crown Court he might step in even earlier.
It's very interesting because when I sit in the press benches of a court, particularly one of the traditional courts at the Old Bailey, I can't see everything going on in court. I can certainly see you, the judge, but I don't realise that you can see everything. You have a perfect view of me in the press bench, of counsel, of everybody else. And although you are obviously listening to the witness, you're listening to counsel, you are keeping an eye on everybody.
Yes, that's right. The judge's bench is almost always, and should be, placed higher than any other piece of furniture in the courtroom other than the dock. And the dock will almost always be directly opposite the judge, and the dock will be raised too. And that's not by accident. Traditionally, we believe that it's right that those in the dock can look straight into the face of the judge trying them. But it is simply a fact that the judge is the one person in the courtroom who can see everything that's going on unless the usher has crept behind him or her and is, doing something administrative.
It must be difficult, Wendy, if a barrister is questioning somebody who is, well, in this case, a more senior barrister, a head of chambers, a highly successful heavyweight barrister who has been around for a long time, or maybe even, I suppose, an expert witness who knows a very great deal more about the subject than the barrister does. And you can almost hear it in the voice of the person asking the questions, if that advocate feels slightly, not intimidated, but slightly uncomfortable in the presence of somebody who really does know what they're talking about.
Well, I think that's right. And of course, your listeners will be able to judge what might be drawn from Jason Beer's voice as he asked those questions. But they might come to the conclusion that compared to his tone of voice when he was cross-examining Venables, it is different. It's not easy, but the job is the same, whoever is standing in the witness box. Lord Drabiner could have been asked a number of other questions, but really, always the advocate has to make a judgment about what is to be gained by pursuing a line of questioning, and it may be that Jason Beer took the view that there wasn't a lot.
There's always a risk that the next question is the one that produces the very answer you don't want.
Well, that I think is exactly what happened here. Drabiner managed to get in right at the end, a swift uppercut to the effect that most senior member of the Supreme Court took a view that agreed with his own. And of course, Jason Beer would not have been in any position whatsoever to challenge that or pursue it. He clearly took the view he should cut his losses at that point. That's what advocacy is about. It never goes all your own way.
Okay, last word on Rough Justice, your new book. You reach a number of conclusions at the end, and one of the questions you address is whether we're closer to delivering justice, particularly to women, in the modern era than we were in the historic period that you compare it with. What's your view on that?
If by delivering justice you mean allowing people to access the courts and use the courts, then I think the answer is yes. The courts have been opened up enormously, in many ways, to many people. But if you are asking, is it still difficult for certain groups of people to achieve the same justice as other groups of people? Well, frankly, I doubt it. But I doubt that the problem lies in the courtroom. The problem, I suspect, lies in getting the case into the courtroom. So we all know that of the women who are in fact raped, a tiny percentage end up with their attacker being convicted. But the failure rate is not in the courtroom. There is a high percentage of convictions for rape once the case gets in the courtroom. The failure in the justice system lies in what comes before, in the slowness of the procedure, in those who carry out the investigations, in those who support witnesses through the period of what might be a waiting time. In many, many ways, that is where we fail people at the moment.
Does that all come down to money, or is there more to it than that?
Well, there's probably more to it than that, but essentially it's treasury-driven, as everything is. Delivering justice is an expensive business. Depends how important you think it is in your society and how you divide available assets up between different calls upon that money.
Prevention is better than cure, and one of the things you say is that we ought to start with young people.
Yes. People might be bored with hearing me say it, but I really think that by the time a defendant steps into a courtroom, we have failed, because the crime has happened and it cannot be undone. The art and the science is to stop offending in the beginning. And to do that, you've got to go right back into the past for people. You've got to look at the opportunities you're giving people and whether they are offending because they're not getting a fair chance that other people in society are getting. You've got to look at the education that we are giving young people as to how they behave. You know, Joshua, when I was sitting, I dealt with enormous numbers of young people, aged from about 8 upwards, when they came into the court after court hours to see what happened there and to talk to a judge. And my experience was, at the age of 8, children completely got that you should not be hurting other people. By the age of 18, a great tranche of them had stopped thinking that way. Somehow we lose children along the route. We don't have to. We really don't. We split up the idea of spending money on education from spending money on justice, from spending money on social services. It really is a mistake to divide things up in this way. Everything is interconnected, and what we don't have is joined up thinking.
Wendy Joseph, KC, many thanks indeed. Your new book, Rough Justice, is published in hardback by Penguin Random House on the 18th of July. And that brings us to the end of this podcast, A Lawyer Talks. Many thanks to my producer, Neil Koenig. This was what we call an on-air pilot, a test run to see what works and how we can improve it. If you have any comments or suggestions, please put them in the comments box on A Lawyer Writes. You can find it by searching online for Rosenberg with a Z and Substack, all one word, and then you should find the page on my website. We're doing another pilot next week, and then I plan to start the podcast on a regular basis in the autumn. Join my free mailing list and you'll be the first to know. Meanwhile, thank you for listening to A Lawyer Talks.